further, we have I'll be speaking on law and technology. Myself, I'm teaching in Manipal University School of Law, which is located in India at Jaipur, Rajasthan. My area of expertise and my research works are in constitutional law, comparative constitutional law, as well as constitutional law in the aspect of India. And so there has been times that we are facing a lot of difficulties when everything is done on online mode. There are a lot of cases of sexual harassment also, that once there was different act which worked on sexual harassment at workplace, that means when you are using, when you're in the office hours. My paper deals with how during the lockdown period there have been, the court have interpreted this offline mode towards the online mode, and all the cases of sexual harassment which are done at the home or during home hours also, because it is work from home. So how those cases court has interpreted. So I'll be playing my presentation. Good morning everyone. Today I'll be delivering on law and technology. And when you see this topic, law and technology, you need to first understand what is the role of law in the society, why law is there in the society, what purpose it fulfills, and how, when there is changes in the society and there are changes in different type of offenses which are committed. Some offenses may be such that which may get advanced with time, and now we see various instances where certain type of online abuses have been started. So we need to keep a check that law, when this types of offenses have been changed and they have become certain type of online abuses, again the law has to be upgraded, because law is in accordance to the needs of the society and it must fulfill that need. So today our topic is law and technology, in particular reference to the protection of women from sexual harassment. The POSH Act, which is enacted in India, how it came, what is the history, and certain type of online abuses which have been started during the time of lockdown, when most of the employees have switched from their their office premises to their home premises, and a culture of work from home has started. So we will see that how this has been evolved and how courts are interpreting the provision of workplace. Because if we want to cover a particular instance under the Sexual Harassment Act, we need to be in specific whether that comes under the definition of workplace or not. So we are going to see certain history and we are going to see certain changes. So when we go to the history of this act, how this act came into force, this was the first instance. This act was made in pursuance to the Vishaka versus State of Rajasthan. Certain guidelines were made on sexual harassment at workplace. The case was an important landmark case into the Indian history. This was where a woman, Bhavri Devi, she was a worker under rural development program, as we can see in the slide, and she was gang raped. Then particularly court said that there must be certain guidelines regarding sexual harassment at workplace to avoid such kind of instances. So court, acting under the jurisdiction of Article 142 of the Constitution of India and talking about the judicial activism, said that there must be certain law to protect the woman from the sexual harassment at workplace. Now, after seeing all this, the Act was adopted under the Sexual Protection of Women from Sexual Harassment, the POSH Act of 2013. After the adoption of this Act, there are certain international conventions that we are following. First is General Recommendation 90 to the Convention on Elimination of All Forms of Discrimination Against Women, which particularly talks about the gender-based violences, gender inequity, which is happening right now. And then we have International Labour Convention on the Discrimination. So according to these two conventions, the workplace and protecting the rights of women, protecting this, giving special protection to the women, as there's certain kind of discrimination which happens at the workplace. It may be regarding wages, it may be any kind of discrimination. So to avoid all these discrimination, the Act was adopted in 2013 in pursuance to these international conventions. Now we see particularly the meaning of sexual harassment. What do we understand by sexual harassment? So sexual harassment, as which is laid down in the Act and according to the CUHK guidelines, there are certain particular instances which can be termed as sexual harassment. This is physical contact and advances a demand or request for sexual favors, sexually colored remarks, showing pornography, any other physical, verbal, or non-verbal conduct of sexual nature, any sexual acts carried out that are directly related to victims' employment or work, conduct that can be humiliating for the woman, and any sexual conduct that affects the health and safety of women. So all these type of conducts may be included into the definition of sexual harassment. Now we are going to see that what is workplace, because to comply any instance under the category of sexual harassment and bringing the act into force, we need to first see that whether that comes under the workplace or not. If it comes under the workplace, only then we can apply the provisions of POSH Act of 2013. So the section 20 of POSH Act defines that sexual workplace means where there is a proximity of place of work, where there is control of management over the place residence where the working woman is residing, or that the residence can be extension or contiguous part of the working place. So the third point is very much important, because work can happen from anywhere. Like if you're sitting in the office, then it comes under the workplace, obviously we can see that. But if you're sitting in the home and it is an extension of your work, that means you're doing a work from home, then whether it comes under the definition of workplace or not, we're going to see these things in the upcoming slides. So when we see certain important cases, there are certain important cases where the definition of workplace have been enhanced, and a liberal interpretation has been given to include all kinds of sexual harassment which are covered under workplace. So first there was a case of Apparel Export Promotion Council versus CUHK. In this case, the court said physical contact is not important for consideration of sexual harassment. So where the court said physical contact is not important, that means harassment, sexual harassment can happen on the online platform also. So covering these nuisances, court first said in this case that physical appearance is not necessary for sexual harassment. Then later in the case of Meda Kotwal and others versus Union of India, court said that a victim has a right. He can not only go under the internal committee redressal mechanism of reporting the sexual harassment, they can also go to the higher courts. Then we have what are the impacts of this POSH law. So we have to see certain impacts, that prevention of hostile work environment. This means that we need to protect the psychological aspect of the woman. A woman against whom sexual harassment is done, she's not only physically assaulted, but there's a mental pressure in her performance, and moreover this mental pressure builds up and makes her unhealthy. So sexual harassment not only affects physically, but it also has a mental consequences. Now we need to see what is unwelcome behavior, because this unwelcome behavior, court has said, this is particularly the subjectivity of a woman. So for one woman it may be reasonable such comments, for other women the unwelcome comments may not be reasonable. So this depends on from case to case basis, the unwelcome comments. So court said this is a subjective element, and further court said there is a quid pro quo harassment. This means in certain cases what happens, there are two persons, one is both are the employees, one at a higher position, other at a lower position. So we take the example where there's a woman which is at the lower position and the male one is on the higher position. Now what happens in this case, the male may ask for sexual favors from a woman which is a lower employee, and if she doesn't give those favors, then he may dismiss the service of that woman, or he may reduce the wages. So in these cases, this kind of harassment usually we see nowadays. So this is a quid pro quo harassment, which is considered under also sexual harassment. Now, what are the virtual abuses which are happening right now? So certain type of virtual abuses we see which have been reported is getting unwarranted video call requests at odd hours. That means you're calling at night, 11 p.m., 11:30. You have certain work hours. That means work from home doesn't mean that you can put your employee to do work beyond the work hours. So this has to be complied. So calling it the odd hours, or we may say that in the certain type of male colleagues have been stalking the women on the social media, sending friend requests, commenting on their pictures when they are not friends. So certain kind of abuses, sexual harassment. It may also include that a male employee is not proper dressed up, or his particular kind of clothing is in such a manner which is very making the woman uncomfortable. All this comes under the kind of virtual harassment. Now, what are the new dimensions which are attached to this workplace? Now, we see this when the technology has come into the picture and work from home culture has been started. So there are different kind of abuses which are happening online, and similarly, the companies and different employers have also considered this aspect that a committee can be set up where online procedure can be followed regarding internal committee, seeing the grievances and action can be taken. So all these kind of abuses can be considered under this. Then we see that there are certain notions of justice, that how this come into picture and why we have included the virtual harassment, because we are following certain notions of justice given by famous jurists. One we say is a dice. Dice says that society has to be in accordance, the law has to be in accordance with the society. So if there are changes in the society, if there are changes, so law has to be also evolved regarding those changes. Second, we have second jurist we can is Henry Meany. Henry Meany says that, so for example, if there is some law and there are changes in the aspects of abuses of that law, and now when the law wants to curb those abuses, so what law has to do? Because parliament may not see certain kind of circumstances. So it is through the interpretation of cases, precedents, the court may include those kind of abuses and curb them. So it is the duty of courts. So for example, now we see sexual harassment at workplace. The definition has been enlarged. All kind of abuses which may be in the proximity, but which extends to your even residence. So those kind of abuses are also covered. So Henry Meany said that it is a duty of courts to consider such kind of abuses. Then we see this is the expanding horizons of workplace and the doctrine of notional extension. It is through this doctrine of notional extension that virtual harassment are also covered under this aspect of WASH law, that sexual harassment at workplace can be considered. So there are certain important cases regarding this. First case was that Swaraj Salt Manufacturing Company versus I. Valluraj. In this case, court said that the theory of notional extension was applicable to an employer's premises so as to include an area to which the workman passes and repasses and going on and leaving the actual work of place. So you're going from a place that also comes under the sexual harassment. If you're doing any kind of harassment or abuse in that aspect, you are still covered. Second, there were certain cases where, like the case of Saurav Kumar Balik versus Controller Auditor General. In this case, the court said that employer cannot escape his liability, saying that premises don't come under the workplace, saying that if a person has been done any offense of sexual harassment. So in the para 31 of the judgment, when we see it says that a residence has to be an extension or contiguous part of working place to come within the ambit of workplace. So any incident of sexual harassment would ipso effecto bring it within the definition as if misconduct or sexual harassment has taken place in the workplace. But that means if you're working in your working hours and you're working from home and any kind of conduct has been conducted which comes under the sexual harassment definition, those aspects of conducts like making such remarks or asking favors or or it may also involve publishing certain type of photos of your employees, taking their screenshots, and so this is also comes under the sexual harassment and uploading them on the social media. So all these kind of instances. So keeping in view the objective of the judgment, a narrow and pandemic approach cannot be taken. The court said this, and it means that the expression office is expense to even at your home. So when you're working from home, you cannot escape the liability of sexual harassment and CUHK. It is under your purview. So it is imperative to take into consideration all these recent technological advancements and the cases we have seen till now, because technology is expanding, and so technology is expanding to the court has said if there are virtual harassments, they also come under the POSH Act, and we are going to include those. So employee cannot escape his liability by stating that it doesn't come under work. Now we have to see that what how sexual harassment is a human rights violation and also. So under Constitution of India, we have a provision of Article 21 which talks about right to life and personal liberty, the most important fundamental right. So it includes that a woman cannot be harassed, and we have Article 14 which talks about your right to equality, no kind of discrimination is permitted. And then we have Article 19(1)(g), which says that the freedom to practice any trade or profession without hindrance. So all these articles protects the fundamental right of women, that is their human rights, protection against sexual harassment. Now coming to the conclusion, I would like to conclude that through all these instances, law and technology has to be in a balance. So whenever technology is increasing, laws has to be made so that we can curb those abuses which can be done under the technological aspects. And similarly, the court through the doctrine of notional extension has already said that even the virtual workplace, if you're working from home, that also comes under the Sexual Harassment Act, and you still shall be liable. So that's all I would like to share with you. And if you have any questions, I'm ready to deal with those questions. And thank you to the university for giving me opportunity to present my views on this topic, law and technology. Thank you, everyone. I didn't see any questions to yet. Any questions, anyone? No questions on the screen, then we'll move on to the next speaker. We have Professor Dennis W.K. Hong from, he's associate professor. He is associate professor from Center for Law and Technology, Multimedia University in Malaysia. And he's also a chairperson for Center for Law and Technology. And his research areas includes IP laws and technology laws, and particularly the paper, when we see the abstract, it deals with that how much the computation laws should be included in the curriculum for the law students. So particularly very relevant topic right now, and important that how much law students should learn this programming to till what extent, and how to make these programmings very interesting so that law students can develop their interest in law as well as programming. So